This isn't just another DWI hearing. It opens with a man accused of breaking bond conditions not once, but 3 times. And Judge Fleischer? She's not one for leniency when it comes to repeat offenders. As this hearing begins, we're stepping into a courtroom that's more like a pressure cooker. Emotions are running high. Stakes are higher. And the man at the center of it all, Mr. Kabir, might be about to lose his freedom for good. What you're about to witness is not only a battle over facts, but a question of trust, accountability, and whether justice means a second chance or finally saying, enough is enough.
And we're here now due to Mr. Kabir having a bond violation. This is our 3rd bond violation report that we have had. Our first bond violation. So I guess let me start up. Mr. Kabir is charged with driving while intoxicated. He was ordered as a condition of his bond not to consume alcohol, illegal drugs, or unprescribed controlled medication.
The judge's tone changes the second she locks eyes with Mr. Kabir. Notice how she doesn't just read his charges, she commands attention, demanding eye contact like a general on a battlefield. This isn't formality, it's control. And when she warns him that a DWI conviction could land him in jail for 6 months, it's not just a reminder of the law. It's a warning flare. Because this isn't Mr. Kabir's first run-in with the system. The question now is, will the court see him as someone who made a mistake, or someone who just can't stop making them?
Sir, I'm up here. I'm not on the floor. Up more. Look at me. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews of the state of Texas. If you cannot afford a lawyer be appointed to represent you, sir.
On July 4th at 3:49 a.m., officers observed a vehicle in a moving lane of traffic sitting idle with damage to the front passenger tire. The defendant was sitting in the driver's seat, slumped over in asleep. Officers woke the defendant and he exited the vehicle. He had red, bloodshot eyes, slurred speech, and unsteady balance. Standard field sobriety test was conducted, and a 6 of 6 on the HGN, 4 of 8 on the walk and turn, and 0 of 4 on the one-leg stand. The defendant refused a breath sample, and blood warrant was obtained, and a blood sample was taken.
Are you on something now, Mr. Kabir?
No, Your Honor. I'm not.
How old are you, sir?
26.
What do you do for a living?
I'm the owner of a healthcare consulting firm.
Here's where the story starts to get messy. Mr. Kabir owns a healthcare consulting firm, ironically, one that works with addiction treatment centers. So the man charged with a second DWI, he's helping others get sober. This contradiction is more than dramatic, it's tragic. And Judge Fleischer smells the hypocrisy. You can feel the disbelief in her voice. As if she's wondering, is this just a business for him? Or is he fighting the same demons he claims to treat? That moral tension, that's what this hearing's all about.
Are we able to go send someone now, Tracy?
No.
Mr. Kabir, if you have a drug or alcohol problem, you better address it. Because if you don't, and I see it becomes an issue, I'm going to address it for you. I promise you're not going to like the way that I do it. Do you understand?
Yes, Your Honor. May I?
Don't. The only thing I want to impart to you that the drugs and alcohol stop now. I'm making it a condition of your bond not to consume alcohol or any illegal drugs. Do you understand?
Yes, Your Honor.
I'm going to randomly test you. If I find that you're consuming, I will revoke your bond and put you in jail. If it becomes a repeated issue, I will put you in a rehab facility.
Judge Fleischer is done dancing around the issue. Her concern isn't just for Mr. Kabir's sobriety, it's for public safety. And here's where it gets real. She doesn't just threaten consequences. She lays out a roadmap, random tests. Jail, rehab, interlocks. This isn't vengeance. It's containment. Because in her eyes, the system has already tried trusting him. Now, it's time to monitor him. Every word here exposes a harsh truth. Freedom isn't free, it's conditional. And those conditions are cracking.
I don't want to have to do that. My only concern is public safety. Do not drive if you don't have a license, and don't consume anything. Do you have a Texas driver license? Do you have valid liability insurance? Okay, we're going to reset your case to give you time to hire a lawyer.
There is a prior DWI from June.
A new revelation drops. Kabir has a prior DWI. That changes everything. Now the court isn't just dealing with a possible offender. It's dealing with a pattern. And legal strategy hinges on that. Prior convictions often tip the balance in. Bond hearings. Why? Because they reveal behavior. And here, the judge is starting to connect the dots. Repeated violations, broken promises, and now, repeated risks to the community. Would you trust this man behind the wheel?
Of this year in Navarro County.
Okay. I'm ordering you now not to drive any vehicle that's not equipped with an ignition interlock. Are you currently on probation or parole or any kind of, for a DWI now?
No.
What's the status of that DWI? Do you have an open DWI right now?
No.
Okay, I'm now going to put a condition on your bond that you're not allowed to be out past 9 p.m. to 6 a.m. I'm going to put a GPS monitor on you, so I know that you're not out in the middle.
This moment reveals the system's blind spots. Due to a hurricane, the court can't test Mr. Kabir, yet they're being asked to make a life-altering decision. That's the razor's edge judges walk. They need to protect the public. Without full evidence in hand, so what do? They lean on patterns, prior behavior, and instincts. In the absence of perfect data, justice becomes a judgment call, and for Mr. Kabir, that's not good news.
Middle of the night. Unfortunately, because of the hurricane, we're not allowed to have people tested right now and I think that you're on something now, Mr. Kabir.
I have bipolar and schizoaffective disorder. I have bipolar and
Then alcohol is not helping the issue, Mr. Kabir. It's only going to exacerbate anything. No more. Do you understand?
Your Honor, at this
Okay.
time, I'm not on any substances. I take multiple medications for my
Kabir's mental health takes center stage. He's diagnosed with bipolar and schizoaffective disorder. Suddenly, this case becomes more than legal. It becomes deeply human. Is he a threat to society or a man in crisis, spiraling under pressure? The law doesn't always handle nuance well, and Judge Fleischer has to make a brutal decision. Treat him with compassion, or treat him like a risk. What would you do?
mental health issues, but I'm not on any unlawful or illegal substances. I'm only on prescribed medications.
Okay, no more alcohol. Do you understand?
Yes.
No smoking marijuana. If I test you for marijuana, are you going to test positive? Okay, don't. So GPS with a 9 p.m. curfew for now, until we know that he's not out and about in the middle of the night. I'm going to have you now go to the jury. We're going to be signing a reset. After that, I will have you take your seat in the jury box, and then we'll be back with you shortly, Mr. Kabir. Okay, how's this? I put defendant must find full-time employment. Why are you trying to leave?
Sir, I was not trying to leave. I just needed to use the restroom, so I wanted to request and ask the officer. I didn't want to disturb you while you were in the middle of session.
Right, don't disturb me, and you just can't walk out.
That quick restroom request might seem small, but in the courtroom, every move matters. Kabir didn't ask for permission to leave, and Judge Fleischer reacts sharply. Why? Because control in the courtroom is sacred. Without it, the whole system can unravel. This isn't about bathroom breaks. It's about whether this defendant respects the gravity of the process he's in. And right now, the answer is looking more like no than yes.
You have to ask for permission. When you walk out, we issue warrants. Do you understand?
I wasn't looking to walk out whatsoever.
Okay, so tell me, you said you own a business. What do you do exactly?
We help treatment centers, or we specialize in bringing in new patients into healthcare treatment centers, specifically alcohol and opioid addiction treatment centers.
You have a monthly income from this.
Yes, Your Honor.
How much money do you make a month?
Well, right now the business is still in a growth stage, so we revenue, but I don't take personal income. I take a small amount of personal income, so you can say $2,000 to $3,000 per month as of current.
Where do you live?
This is where perception cracks wide open. Kabir lives with his parents, drives a BMW, and runs a business bringing patients to addiction centers, yet claims minimal personal income. To the court, this paints a picture not of stability, but manipulation. Is he underreporting income, gaming the system, or just a startup founder in over his head? When financial truth gets fuzzy, judges tend to assume the worst.
Parents' house.
Yet you drive a BMW.
Yes, Your Honor. The revenues of the business are over that amount.
Okay, so you need a lawyer to represent you in this. And it would behoove you to get one really, really quick, because one of the conditions on your other DWI is don't get in trouble and probably not to consume alcohol. Once this other jurisdiction learns of your new DWI, they'll probably going to issue another warrant for your arrest. So you need a lawyer to represent you, and quick. So we're going to let you go today. And I'm telling you, no alcohol.
Yes, Your Honor.
You have an interlock that you're going to, within 3 days, you must get an interlock on your car. If I find that you have not put an interlock on your car, I'm going to put you in jail. And I'm going to tell you, with 2 open DWIs, I usually put bonds at around $25,000 in that time. So beware. You're skirting extremely thin ice at this point. Do you understand?
Yes, Your Honor.
3 days to install an ignition interlock or face jail. That's not a request. That's a line in the sand. But Kabir hedges. What if the installer isn't available? What if the date slips? And with every what if, the judge sees a man preparing excuses before even trying. That hesitation might be the final straw.
I will contact the interlock immediately. I have the information for it, but I don't know exactly the date that they'll be able to install it.
You must get it done within 3 days.
What if the company is not available to do it within those 3 days?
Well, then come back and let us know. Okay. But I'm not going to entertain any excuses. You also need a lawyer to represent you. So get on that as well. As soon as you leave here, start researching that as well.
This is the moment things begin to collapse. The 3rd bond violation is confirmed. The device meant to track sobriety caught a spike in alcohol. And this isn't speculation. It's data. The defense scrambles, questioning procedure, credibility, chain of custody. But to the court, numbers don't lie. And the judge is running out of patience for explanations.
State, does he have a DWI open elsewhere to refresh my memory, please? Mr. Salinas, did he not have a DWI?
He currently, yes, Your Honor,
He has an open DWI where?
in Navarro County.
So we put conditions on him. I can't. Please, Felicia.
The most recent ones, Judge, or there's been a few that we've amended over time.
What are the current conditions now?
The current conditions now are appear in court every time the case is set on docket, no new law violations. Install a IID device in the vehicle, no driving without permission of the court, no drugs, no alcohol. Plan to obtain a scram device, and to submit to drug and alcohol testing at the court's discretion.
Did he have a curfew as well?
No, Judge.
He originally had a curfew, Your Honor, but because there were no issues with that, we had it removed.
Okay.
Yes.
And so now our first bond violation report that we had was September 23rd, 2024. And in that one, he had been in lockout for failure, I guess, to pay. I don't know, which is weird because we normally always pay for all of them. A second bond violation report was filed January 6, 2025. Where I guess he was in lockout again because due to no recalibration of the device. And we now, February 4th, 2025, have a third bond violation. And in this violation,
An important legal crossroads. The defense is trying to discredit the Scram device, and it's smart. Question the tech. Challenge the science. Cast doubt on the evidence. But will it work? The court doesn't need beyond a reasonable doubt, just clear and convincing evidence. And with a confirmed alcohol reading, their burden may already be met.
violation, the defendant was ordered to obtain a Scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's Scram device has reported one consumption event that occurred on January 16th of 2025 at 11:55 p.m. It was also confirmed by a Scram analyst as well. Correct?
Yes, Judge.
Okay, so
Yes, Your Honor. So,
yes,
so to begin with the first amended order for pretrial, so if the state wants a copy, I have a copy to show them, but sure. So, Your Honor, just going to the very first order, as Your Honor just noted, usually agency fees are waived for that. However, the box on that for saying that the fees were waived, I believe were not checked on that. Further, Your Honor, the main purpose here for your determination of giving someone bond in the first place is to establish that they come back to court. So are they a flight risk? And then also, are they a danger to the community? Now, Your Honor, if an interlock device is in lockout on a vehicle, it doesn't start. No one's driving that vehicle specifically. There's no way that they can. I can call a witness to testify that, but I know that you
but that doesn't
are aware of
exclude you
that.
from violating the conditions.
Your Honor,
Are you justifying that because of that you can just?
No, Your Honor, I'm trying to contextualize this because we've been here two prior settings before. I know you've concerned greatly about the number that it's at number 3 now. I'm trying to establish that the first and second, there was no indication of alcohol consumption or drug use during that time.
It wasn't working. How are we supposed to know?
And Your Honor, one of the two main points of determining what kind of bond, both the conditions and amount are, will they return to court and community safety? Here, my client who's being accused of DWI wasn't driving that vehicle. So it was impossible for him to be driving that vehicle, Your Honor. So I ask you to take that into account as far as public safety goes. As far as this latest bond violation, it's the state's burden to prove that my client violated his bond. All we have right now is a report by Scram, but no one is here to testify on behalf of. Well, we can call that, Your Honor, but
Yeah.
sure.
Judge, I spoke with the defense counsel today and he said that he was not requesting to have anybody come here to testify to the Scram device.
We have Felicia that can be called up as a witness to testify as to what happened with and whether he tested positive or not, whether he's consuming alcohol.
It's also the state's burden to prove that he did
So
that. So that's, yeah.
Please.
Yes, Your Honor, we would call pretrial services, Ms. Felicia Charles.
Okay, ma'am, would you please come up, raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay,
So you have first amended order and then second, third amended pretrial supervisions and then the board. So referencing the fourth amended order for pretrial supervision and bond conditions, what I'm showing you, do you recognize this? Yes. Can you tell us what this is and what are the conditions that are checked? These are,
Sorry, could you repeat what you just said?
Sorry, I said I don't know if she needs that. It was an extra paper.
Okay. I just want it on the record.
Sorry.
That's all right.
Yes, these are pretrial bond conditions, and these are listed as appear in court every time the case is set on docket unless the judge waives appearance. No new law violations, install ignition interlock within the vehicle, no driving without permission of the court, no drugs, no alcohol, and then to obtain, we do have a curfew of 9 p.m. to 6 a.m. and then a SRAM device to be installed.
And so what we're showing you is what's been marked as State's Exhibit 1, and we'll tender this to defense for any objections.
No objections.
Admitted as one.
So in this case regarding the SRAM device, can you tell us about that?
Yes, so what exactly about?
What is that? What's the standard procedure someone's supposed to do?
Yeah, so a SRAM device is ordered and it tracks the
Objection, Your Honor. The foundation, I believe the state is trying to ask her to testify as far as are you trying to establish her as like an expert on SCRAM?
And I was not trying to establish her as an expert, just from her experience, what the SRAM device is basically for, which she can testify to as a trial.
I'd ask that the court consider that as that testimony as a layperson, not as for the purposes of establishing expertise.
So I want to know whether there's a violation for alcohol consumption. So, what day do we have any kind of hot blows? What's the amount? Do you have anything of that nature?
Yes, so the report should have been provided to the bond violation email as well of the graph.
And I'm showing her now what's marked as State's.
For the exact amounts and everything, I would need to look at the report that was provided in the email.
Okay, please.
Have the graphs been printed, State, or she's just referring? Yeah, just so we can all agree on what she's referring to.
And I'm showing you what we marked as State's Exhibit 6. Can you please tell us what this is?
So this is a SRAM report sent back to us whenever the device information and data is pulled. And this is what the analysts observe for either tampers or consumption. And this is what they send us back if there is a confirmed tamper or consumption as per.
Here comes the turning point. The defense hammers home a distinction theory versus practice. Sure, the witness understands the SCRAM device in theory, but did she assemble the report? Did she test the device herself? No. And in the eyes of the defense, that weakens the entire foundation of the state's claim. It's a last-ditch effort, but a clever one.
Okay, so this fairly accurately depicts a SCRAM report and how it says it.
Yes.
We will tender defense for any objections and note that this has been, is it correct to say this has been emailed to defense prior to this date?
Yes.
Defense received it, no objection, Your Honor.
Okay, it'll be admitted.
Okay, so can you tell us about the specific dates in this report again that was given to defense prior to today of the basic dates that the SCRAM was not completed properly?
Yes, so the device seems to be fully functioning. And on January 17th, Friday, January 17th, the SCRAM device picked up a peak TAC of 0.078%. And then established a zero baseline once again for the dissipation rates of the alcohol at 9:05 a.m. on January 17th.
Say it again.
9:05 a.m. January 17th, 0% TAC was reestablished for the dissipation of alcohol.
Okay, and for those dates, the ones that match on what I'm showing you as State's Exhibit 2, the bond violation report, can you please, do you recognize this?
Yes.
Can you please read the details of the violations here?
It says the defendant was ordered to obtain a SCRAM device and to refrain from alcohol consumption and not tampering with the device. The defendant's SCRAM device has reported one consumption event. The confirmed alcohol consumption occurred on January 16, 2025 at 11:55 p.m. This information was received on 1/17/2025 and confirmed by a SCRAM analyst.
Thank you, we pass the witness.
Okay.
All right. Good morning. I just want to, if you could turn to, I believe it was it's Exhibit 3, I think, for the Scram non-compliance report, the cover page. Do you see that? Yeah, what she has right there. Oh, is it 6? Okay. Would you since you're close, would you give that to her? Thank you. So just looking at the cover page there, can you read who the agent is on this report?
Justice Turner.
Are you Justice Turner?
Yeah.
Have you consulted with Ms. Turner about this report?
Through the emails, yes, for the bond violation report and the.
What exactly did those conversations include?
The entire.
So let me, sorry, that was a poorly phrased question.
I'm sorry.
No,
I don't understand.
that's my fault. Don't worry about it. My question is, did she consult with you when compiling this report?
Would you be more specific?
Did you help in the assembly of this report?
No.
Okay. Have you ever assisted or aided in the assembly of a Scram systems non-compliance report?
No,
No, no one in the department does. Okay. And do you have any sort of, have you ever worked for Scram systems?
No.
Have you ever had any special training in Scram systems?
Yes.
What is that training?
I actually met with Ronald Grant from Sentinel, the regional representative, about maybe 2 months ago to get an advanced knowledge of this device. This is one of the very few devices that I do have advanced knowledge in, but not expertise.
Sure. And what exactly did this person teach you?
We went
Briefly.
through how to read the graph, kind of how to establish consumption versus a tamper, environmental factors versus consumption, et cetera.
Okay. So during that training, did you ever actually look at a physical device, the Scram device?
No.
So you didn't do any like live experiments where, like, for instance, you put on a Scram and then, drank alcohol to see how that works?
No.
No. Okay. And as far as Mr. Kabir's Scram device, have you examined it prior to this hearing?
Me personally, no.
Okay. And so is it fair to say that you've been thoroughly trained on the theory of Scram device and alcohol detection? Is that fair to say? That let me rephrase that. So you don't have any actual technical experience with how the Scram device detects alcohol in someone's skin. Is that fair to say?
Thank you.
I don't want you to think. It's a yes or no.
I still don't understand.
I'm trying to understand too.
Do I not understand how a Scram device works, or have I not for myself? And
Sure. So, this is pretty, is it fair to say like the science is kind of advanced here? Like when you received your training, did you have the personal opinion that was advanced science that you were learning about?
I believe so.
Okay. And you don't, so basically it sounds like your training, and correct me if I'm wrong here, your training was mostly so you could be able to make sense of what a report says and not necessarily how the actual device itself works. Is that fair to say?
Partially, yes.
Okay. What's what am I partially wrong about?
Over, yes, reading the graphs, but then also what kind of would entail, what would mess with the device.
Okay.
Essentially, as well with tampers, environmental factors with that, makeup or placing something between the skin, how things are worked around with the device, how people evade from, having the correct reading on the device.
Sure. And so that's, you basically learned that all in theory, right? There were no withdraw that question. So I'm just saying there was no actual, you didn't look at any studies. Did you read any studies when you did this? Okay.
I actually met with him due to another case. I wanted to further understand it. So we examined the report for that.
Well,
and also reviewed some of the peer-reviewed articles.
Well, that's great. I'm glad that you want to, a lot of people won't. They'll just kind of do their jobs, right? I'm glad that you want to further knowledge, but what I'm trying to get at is it's fair to say that
This is where everything comes to a head. The judge's voice, once measured, is now raw. She's had enough. She's let Kabir slide twice before. She warned him. She gave him chances. And he blew every single one. Her decision isn't just legal, it's personal. At some point, I become an enabler, she says. And just like that, his bond is revoked. The gavel falls. The door closes.
knowing how something works in theory and actually examining the actual thing itself, the practicality of it is different, right? Do you agree with that statement?
Yes.
Okay, so without actually having examined in your own personal observation how a scram device detects alcohol in someone's system, it seems that, is this fair to say that you're very, very well versed on theory, which is probably more than some other people, but not necessarily on the practicality of detection?
Objection asked and answered.
Okay, just, let's go.
All right. Just answer the question. I don't know if that was an objection or sustained or overruled.
Let's just move on. I mean, we're here to see, is there a positive blow or not? She's testifying that there was.
Sure. I'm just saying that this, I'll make my argument in closing. I don't have any further questions. Thank you.
Okay, closing, or wait, hold on. Anything further from the witness?
Two very quick questions, Your Honor. So do you get notifications if the scram device has been tampered with?
Yes, we get notified of tampers and consumption events.
And you get notifications if it's been cut off? Like, just what's been going on with the scram device? You get those notifications?
Yes.
Okay, thank you. No further questions.
Matt?
No further questions, Your Honor.
Okay, thank you so much. Okay, argument.
So, Your Honor, this is a pretty basic, simple case. The bond violation report is evidence the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device was reported on one consumption event. This happened on January 16th of this year at 11:55 p.m. and this information was received on January 17th of this year at 5:18 a.m. And clearly, there were up to 4 amended orders for pretrial supervision and bond conditions. It was obvious which the defendant was supposed to do, and he directly violated the order. It was evident by the pretrial services and bond violation report. So it's pretty clear here that we would be asking to revoke bonds in this case.
And we would just like to urge that this is a fair and convincing standard, as I already know, Judge, and it's not beyond a reasonable doubt. I don't think that we need a scientist here to prove that the scram device is a device that can be detected.
Okay.
Yeah, Your Honor, I agree with State insofar as this is a simple matter. Where we disagree is I think a scientist was needed. I think someone who actually has the technical know-how of how this violation report came to be. The state did have that standard of clear and convincing to prove that my client violated this. So far, all we have is a piece of paper that is, at least for right now, is supposed to have been prepared by someone else who is not here to testify. There's no ability to cross-examine them on their expertise, on any notions of false positives, on any issues that a technical expert would actually know about the device. And without that, Your Honor, I think it's very clear that the state failed to prove their burden of proof that my client consumed alcohol. And I would ask that Your Honor, again, not revoke the bond, keep it as is. My client's here. There hasn't been any warrants for his arrest issued since he's been coming to this court. And in the allegations itself of the underlying offense, there is no allegations of injuries or accident to persons. So again, just take into account that you need to take into consideration flight risk and safety of the community. Nothing that's been established here in this hearing or outside of this hearing should lead the court to believe that my client is a flight risk or a danger to the community. And with that, I'd ask that you not revoke the bond, Your Honor.
And Judge, these devices are new.
3 strikes, 3 violations. And now, 1 revoked bond. Mr. Kabir walked into that courtroom with hope and walked out in custody. Judge Fleischer didn't just rule on law. She ruled on trust, accountability, and the limits of compassion. This case isn't just about alcohol or devices. It's about when the court stops listening and starts acting. If this breakdown stunned you like it did us, smash that like button, comment your verdict below, and subscribe for more deep dive. Courtroom commentaries every week. You won't want to miss what comes next.
Say it again.
These devices are used all the time.
Well, their use all the time is
Just so-
irrelevant to needing an expert to testify on that.
Absolutely. I absolutely appreciate your tenacity. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in. He had a second violation. I didn't take him in. Now he has a third violation. It would be unreasonable for me not to. I told you that there was no tolerance in this case. You yet refuse to comply with bond conditions. I find by clear and convincing evidence that you refuse to comply with bond conditions, and I have bent over backwards not to put you into custody. But now we have a positive blow. We have someone who has testified to it, and I believe it. So I am now revoking your bond. He goes with you.
We have the positive THC or stuff.
He had a positive THC, right?
Yeah,
As well.
that we sent him earlier this week.
He also tested positive for
THC.
marijuana as well.
Well, Your Honor,
Yeah, this week.
that wasn't, are we still on the record then? On the, okay. Well, I would also want someone to come testify about that, Your Honor, but you know, that I'll make, I know, but I know you already made your ruling, but I was ready to testify on that because they don't have anything on chain of custody on the test itself, on whether it tests cannabinoids, which Delta 8, hemp. There are a bunch of things that are THC related that could pop positive for THC that aren't THC.
Regardless, we admonish him not to put anything in his body that doesn't have any delta whatever. Regardless, it's number 3, goes with you. Off the record. Sorry. Thank you. But I just can't, with an open DWI and a third, that's it. I can't just keep doing it. You know, at some point I become an enabler and I can't do that. I can't keep doing it, you know? So.
Well, I mean, Your Honor, I understand you're revoked the bond. Would you consider raising it to?
Well, I am going to raise it, right? I'm going to raise it to 7503 now.
Well, and look, I'll just, if you could take this into account, Your Honor. This is a hired client. You know, he has every intention of taking this case to trial. So I would, you know, just, I'm not Chief, Your Honor. So if you could keep that into consideration on that.
It's, you know, and it's
I understand.
representing him in Navarro too.
No, I'm in touch with his counsel there, but no, I'm not representing him there. Yeah.
But tell him this, that he's lucky that he didn't revoke him on the first 2 cases, considering that he has an open, you know, really, because, and I'm telling you now, I don't know how I didn't, but I can't just keep doing it. I can't.
75.
7503. Yeah.